It's another episode of What is Trending. My name is Angelo Himalayas, your anchor. Today was the day set aside for the hearing by the tribunal, talking about the Presidential Election Petition Tribunal that was scheduled to take place today. And of course, it came and it's gone. It took place. But it seems what took place today was like a pre-hearing to what was actually on ground. So having established their cases, the tribunal has set aside the 10th of May, that is 2 days from now, for the actual hearing of the proceedings of the petition, okay? And that's what we are all putting our hands together to see how we could achieve that on 10th of May, 2 days from now. So we'll see if the judiciary can dispense justice or not. But aside that, there has been lots of questions asked by Nigerians, okay, about why the court was adjourned, what are the processes, why must it be 180 days stipulated for the tribunal to take judgment over petitions, especially both presidential and gubernatorial, and why is it that the tribunal is delaying some such petitions that have been before them for like 2 months now, and right now we are running helter-skelter because 29th of May is by the corner, and so on and so forth. Lots of Nigerians have asked plenty questions. Some have sent me direct messages, some have even sent me physical messages, and so on and so forth, for me to explain what really has been going on and what really wants to go on according to what Nigerians want to hear. That is talking about whether Peter Obi is going to be victorious or Asiwaju is going to continue to be president-elect. Yes, so in the wake of that, I have a very good answer for everyone. Everybody, if you know your question, it falls under this, I have an answer for you. Now, a lawyer and a policy analyst, Isaac Anumudu, has come on air to explain drastically and carefully every question. And I'm going to tell you, I'm going to explain these questions while he answers you, okay? Now, the truth is this. The truth is this. The truth is bitter and needs to be heard from a fearless legal practitioner. And we have that in Isaac Anumudu. I will take the first question without wasting much of your time. The first question is this. Number one, since constitutionally the tribunal has 180 days to preside over the petition, which is unacceptably long than expected, when does the 180 days start to count? Is it from the day the petition was filed, or from the day the pre-hearing started, or from the day the real hearing starts? That's on 10th. Well, listen to Anumudu there.
It should have started being counted from the time the petitions were filed, because that's when the work of the tribunal was activated. Don't forget, this is not the first time the tribunal is sitting. Most pre-hearings had gone on last month of April. If you remember, there was an objection by the APC that the presidential candidate of the Labour Party, P2B, was not even qualified to have, contested the election ab initio. That application has already been taken and dismissed by this petition tribunal.
What is really the stipulated duration accrued or accorded for hearing by the tribunal? Is it just 180 days or more? And what effect does this have on the polity? Must it be 180 days? Okay, or can't it be less? Like in the case of Kenya, like 14 days. Can't it be 18 days? Can't it be 60 days? Can't it be 28 days? Must it be 180 days?
About the time within which the tribunal should go about its job and the effect it will have on the polity. And I'm sure you would have been referring to section 285, subsection 6 and 7 of the Constitution. And that section talks about giving the first tribunal, which is the Court of Appeal, 180 days within which to conclude its hearing and determination of the appeal. While section 285, subsection 7 now subsequently give the Supreme Court, which is the final court on this matter, 60 days, 2 months, within which to hear and determine the appeal from the Election Petition Tribunal. Now, many people have misconstrued this to indicate that the tribunal must spend 180 days. If you read that section, nothing in that section says or even suggests that. The only thing that section seems to say is to impress on members of the tribunal the need for expedition, for speed, in view of the sensitive and peculiar nature of election petitions, that they must not exceed 180 days. But there's nothing there that says they must wait for 180 days. No.
And they must use it all up.
Or they must use it all up. Nothing says that these petitions cannot be concluded in 7 days. Nothing also says that the Supreme Court must use up the entire 60 days, 2 months before it decides the appeal. In fact, to underscore the exigency, the Constitution went further in section 285 subsection 8 to say that in order to expedite, nothing warrants even the tribunal to give reasons for its judgment. In other words, the tribunal can simply say, this is our judgment, we'll give you reasons later, just to ensure that this thing is expedited. That's what section 285 subsection 8 says. That underscores it.
Now, if this Presidential Election Petition Tribunal can sit and complete sitting in 14 days, as we all are asking, how can it be done? Which legal practitioner would come out fearlessly and explain the short and brief process of the Presidential Election Petition Tribunal sitting, so we all will know that our judges at the tribunal are just playing a case of delay tactics? Well, here this process is carefully explained by Isaac Anumudu. I respect this explanation. He has shown us that the tribunal are playing a long ball game. They are playing a kind of delay tactics. They are playing a sort of game that we can't just understand. Isaac Anumudu is a legal practitioner. Is it because he's not part of the tribunal? He has come out to explain gradually how you can achieve this tribunal in 14 days. Hear him. You will even go to court and do this yourself.
For example, the candidates have 4 major grounds for their petitions. I'm talking about the 2 major candidates. There may be other candidates, but the Labour Party, the PDP, and their presidential candidates have filed petitions. And, for example, and their petitions are similar. The summary of it, which is they are challenging the declaration of the APC candidate as president-elect on one major ground, that the constitutional requirement for that declaration was not met at all, and therefore INEC ought not to have made that return. They feel very strong about it, whether rightly or wrongly. And they hinge that on section 134, subsection 2, A and B of the Constitution, which says that for you to be declared the president-elect, where there are more than 2 candidates, you must have scored to 25% of 2/3 of the votes in 2/3 of the states of the federation and the Federal Capital Territory. And they said, whatever you scored, if you did not score 25% of votes in the Federal Capital Territory, you should not be declared president-elect. Now, they have their reasons. The other parties feel, no, it doesn't. It's wrong in law. They cited many cases, And the other people too have the argument. They say, how can you say you must get 25% of FCT? If you get 25% of about 30 states, why should FCT be the decider? The other people are saying, no, you must interpret the law. And the law says you must have 2/3 of, this 2/3, 25% of 2/3 states, and means conjunction, and means plus, and means including, and means together with. So if that's what the law says, that can be decided by the tribunal. It doesn't need 180 days. You can call the lawyers because the result for FCT is on the table. INEC has the certified result. It's online. If this party did not make 25%, come, all councils, come and address us. The tribunal can invite the parties, come and address us one day or 2 hours. Does this lack of 25%, is it fatal or it's not? And after addressing, the tribunal can adjourn to the next day and give its decision and even tell you that I will give you reason later. That's what section 285 sub 8 empowers them to do. Now, if that fails and does not disqualify the APC candidate. You can go to the next one, which is the grounds of the opposition under Section 115 of the Electoral Act, which forbids double nomination. Section 115D specifically forbids a candidate from taking nomination forms and filling nomination forms for two elective positions. It even went further to criminalize that misadventure in Section 115 subsection K, 1K, by saying that the person will even be sentenced to 2 years imprisonment if you are found to have filled two nominations. Now, the opposition parties allege that the vice presidential candidate of the APC filled two nomination forms for both Senate and vice president. Now, they are saying that that is fatal, considering the clear, unambiguous provisions of Section 115 of the Electoral Act. The matter is before the court, so we cannot conclude that this person is right or that person is right. But it is something that the tribunal can ventilate and deal with in one day. Address me for 2 hours. The forms are there. Certified true copies can be procured from INEC. Address us that by law, should this candidate be disqualified? Because if the vice president is disqualified, automatically it will affect the presidential candidate. And that does not require 7 days. Because it does not require calling of witnesses. It requires getting the certified true copies and the parties addressing the court on what the law says on that. Now, assuming you scale that second hurdle, there is the third hurdle, the issue of the non-forfeiture, non-committal forfeiture that happened in the United States of America for $460,000. Was it fatal? Is it such that falls within the contemplation of our constitution that any person so convicted or so found guilty for anything money laundering, blah, 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 should not aspire or should not be validly elected as our president? That again is sub judice. I can't stay here now and say this is what this is correct argument or the other one. But the parties are strongly contesting that that is an issue. If it is so, it doesn't also require you to call witnesses from the 774 local government. No. All you need to do is someone, whoever can give you certified true copy of that judgment, which you're already seeing online, and get the parties to address the court. What is the legal effect of this on the candidacy of the APC? 1 week is enough for that. 1 day for this party, 1 day for that party, 1 day for that party. And the tribunal adjourns for 2 days and delivers judgment. The presiding officer can issue an order, amending it and saying, for this purpose, we are going to deal with these 3 issues within the next 3 weeks, within the next 2 weeks, within the next 1 week. Therefore, counsel, come tomorrow prepared to address us on X, Y, Z. It's only when these 3 fail that you now talk about calling witnesses from all the states that some of the candidates claim they had more votes. The PDP candidate claimed he got more votes in Adamawa than was accredited to him. He got more votes in Rivers than was accredited to him. The Labour Party candidate claims that he got more votes in Lagos, more votes in Rivers, more votes in Plateau, more votes in Kaduna that was credited to him. And that if those votes are actually returned back to Labour Party, like the case of Lagos where the PDP person even came on air and said Labour Party got 955,000 votes, but they were given 550 votes. Now, if those 400 votes they are calculating is all given back to Labour Party claims that it got majority of lawful votes in the election. PDP claims so. APC also claims so. So that is the one that may require you to call witnesses, look into IREB, as you said, look into, the details of beavers. But we don't and we must not get to that.
Now, constitutionally, according to Section 13 and 14 of the 1999 Constitution of Nigeria, as amended, Nigeria should be a state, I quote, Nigeria should be a state based on the principles of democracy and social justice. Are we abiding by law? Are we in the country, or is the country abiding by Section 13 and 14 of the 1999 Constitution as amended? Are we flowing through principles of democracy and social justice?
What is the social justice here? If 3 people have contested election and the result has been declared, and that result, the law allowing the announcement of that result provides for that result to be subjected to scrupulous judicial ventilation, and parties have gone to court. Is it not just? Is it not mandatory by Section 13 and 14 for the tribunal to expedite, when it has power so to do, to expedite and come to a decision before any of these 3 people is sworn in? Is it not just? Is it not social?
All right, now, since the mistake has been made, if you've been following the trend of events, you will know that right from the Justice Ways time, during the Obasanjo era, when Justice Ways made a certain proposal about the change of some parts of the Constitution, where it is just mandatory that all petitions or all petition tribunals should be heard before anybody is sworn in. But this particular proposal or this particular act has been thrown forward and postponed over and over again. So if we don't amend this part of the Constitution, we will continue having this issue where someone wins and then someone challenges the results and then he's sworn in, then we can't do anything about it. That's what we're avoiding in this particular case, okay? Because elections will always be challenged, because this is Nigeria. So can we amend that part, talking about section 285 of the 1999 Constitution, that allows hearing by the tribunal even after swearing in the president or anyone involved in this? Is this right? So can we amend this? Is there anything that can be done about this? And if there is, who can do this? Who has the power to do this?
Let me use this opportunity to also call on the incoming 10th National Assembly to quickly amend section 285 to provide that all election contestations should end before swearing in, because it's actually unfair and offense section 13 and 14 of the Constitution. It does not create for the social justice that should exist in our electoral process. If it is possible to bring it down to 180 days plus another 60 days, which is 8 months. If it were possible to bring it from 3-4 years or ad infinitum to 8 months, it's still possible to bring it down to 2 months. It's very possible to bring it within 8 weeks. I've just told you how it can be done.
All right, I hope you've heard it all there from Isaac Anumudu. He has explained everything. I don't think I have anything to add more from what he said, because he's a master in his field. He has an explicit mastery of whatever he read. So his explanations there will show you how widely read he is and how quickly understood he is worldwide, of course, as regards what he has explained. Thanks for joining us. Don't forget to like our videos. Don't forget to share it. Make it go viral. And don't forget, keep a date with us on 10th May 2023, which is supposed to be the day for the final hearing. See you next time.